going to head over to Kansas today. I am not sure if you remember the Liang Li case. It has been a minute. He was pulled over while driving down the highway for speeding. I would have sworn, but apparently I am wrong, and it was a traffic signal violation. The problem was when the officer walked up to his car, he smelled a little something something and ended up searching it, and, well, let's just watch it, and then I'll give you the update. When a friend asks you to drive their sports car cross country, check the trunk. That's all I'm saying.
All right, good afternoon. This is first appearances. We only have a couple. We have one that's in custody and one that's out of custody. We're going to start with Liang. I think we should have an interpreter, and I apologize. Is this Vietnamese or what is the interpreting language?
I was told it's Mandarin.
Mandarin, okay.
Hello,
Hi, Kathy. How are you?
this is Kathy.
Okay.
Good, thank you.
Are you the Mandarin interpreter?
Yes,
Have you had any chance to speak with Liang or Liang before now to make sure that you're communicating well?
no, I haven't. I have just notified I have this assignment
Okay.
earlier this morning.
Okay. Do
so
you
I
want to
have-
go to, we can put you in a private room with him and let you confer a little bit so that you can represent to the court that you believe, you're an appropriate interpreter for him.
Yes,
Okay, let's do that to make sure that we're all on the same page.
okay,
So
thank you.
let's put you in a breakout room and we'll go ahead and take up Jeremy Brown's case. Okay, did you have any trouble communicating with Liang Li? You're muted. You need to turn on your, there you go.
Is it, okay.
Did you have any trouble?
No problem. I just told him who I am, and just confirmed the language wise is all good.
Okay, well, I'm not gonna swear you in because we're not gonna take testimony from anybody. Possession of marijuana with intent to distribute in the state of Kansas. They're alleging that he had 63 pounds of marijuana, that's why it's a distribution or intent to distribute case. And it is a level 2 drug felony in the state of Kansas.
So, you know me and my curious mind. What does 63 pounds of marijuana look like? So I Googled it. You'd be surprised how many people get caught with 63 pounds of marijuana. Interestingly, in 2017, it was worth 3 times what it's worth in this clip.
Okay, I don't see him, so I just talk.
Yes, you would have
okay.
to go to the
Yes,
screen.
I can see him now.
Okay, yeah.
李良，你听到我吗？李良，你听到我说话吗？
可以听到。
刚才法官说，这法庭，说你拥有，持有，鸦片，然后还有，所以当时持有63磅，所以给你的罪名是持有并。
我可以说话吗？
He's asking, can he talk?
No, I'm just here. I'm not asking him whether he agrees with the charges or not. I'm just here to advise him of what he's been charged with by the state and what the penalties are if he's convicted. I'm going to enter a not guilty plea for him. I don't want him to say anything that might incriminate himself. I'm not asking him whether or not he agrees with the charge, but I have to advise him of what he is charged with at this point.
好的，
Okay,
He
so
said
it's
okay.
alleged in count one that on or about the 25th day of July, 2023, he had in his possession or under his control more than 450 grams, but less than 30 kilograms of marijuana.
Excuse me, you said more than 30 kilograms?
No, more than 450 grams, but less than 30 kilograms.
Kilograms.
If convicted of a level two drug charge, the sentencing range is 92 months up to 144 months with the Kansas Department of Corrections, depending on his criminal history, and up to $500,000 fine.
500,000.
He's also charged in count two with not having any drug tax stamps.
Y'all, what is going on in the state of Kansas? So it's okay. You want to be a drug dealer, you know, that's still illegal and all. And marijuana is still illegal. But you got to pay taxes on your illegal shit. What? 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 Are you serious? You have to pay taxes on your illegal drugs, whether you plan to consume them yourself or distribute them to others. Otherwise, you get a separate charge, and they can even take your personal property to satisfy whatever debts you may owe. Apparently, this law was passed back in '87, and it applies to the possession and or distribution of marijuana and controlled substances. And the rate for marijuana is $3.50 per gram. Wow. Other controlled substances sold by dosage units rather than weight for 10 doses. It says the tax rate is $2,000 per 50 doses. So I don't know what the 10 doses, oh, the threshold is 10 doses. My mind is blown. So we're going to tax drug dealers. It's an anonymous program, so you know, you won't get caught for the illegal drugs you're dealing that you're buying stamps for. What?
Okay.
I'm going to enter a not guilty plea for him.
Okay. Okay.
This case is assigned to me, Judge Satterfield. I'm going to appoint Jim Watts to represent him, but he may hire an attorney of his own choosing if he desires. And he goes to the jail on Wednesdays usually. So I want the jail to make sure they let him know, and we need to let him know that Jim Watts is there, and he's going to need an interpreter and a Mandarin interpreter, and he can hopefully make a special appointment to get together with him before our next hearing. I'm going to set this for preliminary hearing, evidentiary, on Wednesday, September 6th at 9 a.m.
September 6th and 9 a.m.
Yes, we will need an interpreter. So the court will get a hold of you for that.
Okay. Excuse me, can I ask a question?
Yes,
You said he is going to jail on Wednesday. Is this the same Wednesday, September 6th?
No, I was telling the jail that I want them to make sure that if Mr. Watts shows up today, that they let him know that he has Mr. Liang Li as a client. So he can start getting prepared for that, because he'll need to have a interpreter to visit with him. So the sooner he knows about this case, the better. So that you don't have to tell him that. I was talking to the jail, not him.
Okay.
So he is set for an evidentiary preliminary hearing on Wednesday, September 6th at 9 a.m. and he will have an attorney.
Okay.
So, Mr. Sweeney, I'm talking to you. You may need to contact KVI, hopefully given the quantity and amount. They can maybe expedite their testing for this hearing, or you're going to have to decide how you're going to handle it. I know it's a fairly quick turnaround, but given the fact that he needs an interpreter and he may remain in custody, I want to go ahead and get this set for an evidentiary hearing. I need to ask Mr. Liang Liang Li some questions so that I can set a bond. Will you ask him, please, where he's from? Where was he born?
He says, I was born in China, but I have been living in Ohio, US for 5 years. And over there, I'm doing conducting the business of transportation. Okay.
So is he here on a work visa?
李良，那么你在这儿是工作签证吗？
我是在这边是，就是我的爱人，他申请的是就是政治庇护，正在申请绿卡。我第一次来美国是作为读PhD 过来的，然后是在俄亥俄州立大学读的 PhD， 是在2013年。
My wife is applying for a green card right now, and my first visit, very first time I came to U.S., I was going to Ohio University to obtain PhD degree. That was 2013.
Okay. All right. I'm setting his bond at $250,000 cash or surety, and he's not to leave the country.
好，法官给你设的这个赎金是25万美金，然后你不可以离开美国国境。
Mr. Sweeney, do you have anything to add to that?
No, Your Honor.
我
Does Mr. Liang Li or Liang Li? Liang Li?
yeah
李良 ，Yeah，
yes
Liang. Okay. Does he have any questions?
你有没有什么问题？ He says, for this case, I wasn't intended to do anything, and also because it's my first time arrested, I plead judge to can you reduce this amount, because this amount is way too high for my ability. I have two children, the older one is 9 years old, and the younger girl is only 5, and she just had a surgery. So I plead to be granted with a lower bond amount, so I can quickly go home to take care of my daughter.
Okay, hold on just a minute. I'm gonna look at the probable cause affidavit that the officer should have submitted with this case. But tell him the reason the bond is so high is because of the amount. It creates a presumption of distribution irrespective of what he believed his intent was under the law. It's a large amount, so it's a presumptive prison case. It's a high level offense, and it is presumed that he possessed with the intent to distribute based on the amount. Now that's a rebuttable presumption, but given that and the fact he has no ties to this community, is from another state and is not a citizen, so he's a national of China, I need to set a high bond given all of those reasons. But I'm going to take a quick recess and get a copy of the probable cause affidavit and review that because I want to determine if there were any other passengers and the surrounding circumstances. So if you could let him know that, I'm gonna grab the affidavit. I'll be right back.
Yes, Your Honor. Li Liang.
All right, it looks like he was the sole occupant and the driver of the vehicle in which the black garbage bags or the trash bags were found in the back of the 2016 Porsche. So there are no other individuals involved, at least at the time of the stop in this case. I need to move the hearing from 9 a.m. on September the 2nd or September the 6th from 9 a.m. to 1 p.m. So his hearing date is still Wednesday, September the 6th, but it is at 1 p.m. instead of 9 a.m. Would you let him know that, please? Give me just a minute here. I'm checking on something. Let him know that his court-appointed attorney contacted us and he had a conflict at 9 a.m., which is why it was moved to 1.
Yes, I heard the time change. I still have a few questions.
All right. What are they?
你讲吧。I have a few questions. The first of my questions, my occupation, my business is international transportation, and I have a fleet of vehicles, and you can you can check on the vehicles I have, and my vehicle number is DOT 3626666. Your Honor, I have no idea of this this car I was driving had these marijuana at the back. I was just helping my friend to drive this car from Oklahoma City to Kansas.
Okay. He'll need to talk to his attorney about that. The officer smelled a strong, very strong odor of raw marijuana emitting from the car. And the approximate street value of that marijuana was in excess of $60,000. So this is a very serious case, and he'll need to talk to his attorney about that between now and his court date. I've set a bond and I've given him a court date. And the rest of his questions he'll have to discuss with his attorney, okay?
Your Honor, if I may explain that for my 36 years old life, I have never consumed marijuana or any drugs. So I have no idea that smell in the car was marijuana.
I don't want to hear anymore because I don't want him to say anything that might incriminate himself. He's presumed innocent. I entered a not guilty plea for him. Now he needs to talk to his attorney. I've looked at the probable cause affidavit and determined there was probable cause for his arrest. The next step is a preliminary hearing. And the court will take up any matters that his attorney presents at that time. I've set a bond based on the level of offense, based on the fact that he may enter and return to China without extradition. He has no ties to our state or our community. It was a large quantity of drugs in the vehicle. And so that is what my job is to do. Give him a court date, give him an attorney, make sure there's probable cause for the arrest, and set a bond. And that's what I've done.
好的。
All right, we are
Okay.
adjourned. Thank you, Kathy.
So for some reason, I would have sworn the initial charge was speeding, but apparently it was a traffic signal violation. I guess it's a good thing this sat around for a couple weeks because I was able to determine that I am not crazy. I know, shocking, right? So the reason I thought this was a traffic ticket is because they never discussed the details of the stop during this hearing that we just watched. And they also don't publish the affidavit of probable cause that she discussed multiple times. So when you go through and you're looking for charging documents, all it has is this one that says count 1, count 2 with the explanations of what he was charged with. If you notice in this document, he is only charged with the 2 drug-related offenses of possession with intent to distribute and no drug tax stamp, which is still bizarre to me. And there are no traffic citations related to this. However, if you look at all of the cases, on that same day, he was issued a traffic citation for speeding. He was going 90 miles an hour when the speed limit was 75. Now, the reason this confused me will make sense in just a minute when we go through and read the motions that have been filed since the case we just looked at. So at some point after that disaster of a hearing, Mr. Li hired an attorney. That attorney filed a motion to suppress the evidence. That motion relied on some pretty interesting case law, in my opinion. So I'm actually going to read you the motion, which is not my favorite thing to do, but the premise for why they're asking for it to be dismissed is pretty interesting based on a couple different factors. Also, just so you know, there were a couple follow-up hearings. However, they were all in person and none of them were on Zoom. Comes now defendant Liang Li by and through his counsel of record, Kurt P. Kearns, and moves this court for an order suppressing evidence obtained against him on the grounds that the admission of the evidence would violate the 4th, 5th, and 14th Amendments of the United States Constitution, Sections 10 and 15 of the Kansas Constitution, Bill of Rights, and KSA 22-2501 and 22-4609. In support thereof, Mr. Li states the following. Number 1, when a motion to suppress is filed, the prosecution bears the burden to demonstrate that a challenged seizure or search was lawful, citing State v. James. 2, the 4th Amendment and Section 15 of the Kansas Constitution, Bill of Rights, protects the people from unreasonable search and seizures of their persons, houses, papers, and effects. Searches conducted without a warrant are, per se, unreasonable, subject only to a few established exceptions, citing Fitzgerald. Number 3, Kansas law also prohibits the use of racial and other bias-based policing in constituting a reasonable and articulable suspicion that an offense has been or is being committed so as to justify the detention of the individual and the investigatory stop of the vehicle or of probable cause to conduct a search of an individual or a conveyance. KSA 4609 B and C. On July 25th, 2023, Trooper S.R. Walker was driving northbound on the Kansas Turnpike and saw a Porche Cayanne driven by Liang Li exit at the South El Dorado exit. The trooper followed Mr. Li as Mr. Li used his left turn signal to turn at the first signal after the turnpike exit. Mr. Li then used his right turn signal before changing from the left-hand lane into the right-hand lane. Then Mr. Li used his right turn signal before moving into a right turn lane and then turning into a Walmart parking lot. The trooper immediately conducted a traffic stop and Mr. Li complied. The trooper called in the license plate from the Porsche after the stop had been effected. When the trooper approached Mr. Li's vehicle, he indicated that he could smell the strong odor of marijuana, even though the video recording of the incident appears to show that it was at least somewhat windy at the time. The trooper told Mr. Li that he had stopped Mr. Li because he had failed to signal before moving from the left lane to the right lane. Mr. Li indicated that he had in fact used his signal, and the dashcam video provided by the state confirms that fact. Jumping in here from the editing room to note that this is why I was so confused. There is zero mention of anything related to speed, so I'm wondering if perhaps he had been pulled over and then was pulled over again. Is something interesting's going on? I'm not really sure what. The trooper directed Mr. Li to exit his car and move into the trooper's patrol car, where he questioned Mr. Li about whether there was marijuana in the Porsche. Mr. Li denied the presence of any marijuana and continued to ask why he had been stopped. The trooper continued to indicate that Mr. Li was stopped because he had failed to signal when he changed lanes. After speaking with Mr. Li for a short time, the trooper told Mr. Li that he was giving Mr. Li a warning for a failure to signal the lane change, yet directed Mr. Li to stand at the front of the Porsche and put his phone on the hood of the car, at which point the trooper immediately opened the driver's side door and began to conduct an evidentiary search. This search eventually revealed several packaged bags of marijuana located in other bags in the back of the Porsche, changing an erroneous basis for the stop. In the video provided by the state, the trooper told Mr. Li that he had stopped him for changing from the left lane to the right lane without using his turn signal, citing the video at 2 minutes and 45 seconds. In fact, the video clearly demonstrates that Mr. Li did use his turn signal before he moved from the left lane into the right lane, the video at 1 minute and 34 seconds. And Mr. Li again used his right turn signal before he moved from the right lane of traffic into the right turn lane, the video at 1 minute and 45 seconds. Although the trooper told Mr. Li he stopped him because he failed to use his signal when he moved from the left lane to the right lane, the dashcam video shows otherwise. Perhaps for this reason, the trooper changed the basis for the stop in his arrest report, indicating that he stopped Mr. Li because the driver abruptly moved into the turn lane for the center, I think that should be from the center entrance to Walmart at the 301 South Village, and continued traveling east in the turn lane with no turn signal activated. Narrative report at paragraph 1. In fact, the dashcam video shows that Mr. Li did activate the right turn signal before he moved from the right lane of traffic to the right turn lane, leading into the Walmart. Video at 1 minute and 47 seconds. So the trooper's revised basis for stop Mr. Li is belied by the video record in this case. The trooper also indicated that Mr. Li had potentially expired registration, narrative report at paragraph 1, but the trooper did not call in the license plate until after he had seized Mr. Li, and he also never suggested to Mr. Li at the time of the stop that he had pulled him over due to an expired registration. A traffic stop is a seizure governed by the Fourth Amendment in the Kansas Constitution Bill of Rights. In order to justify a traffic stop, the state must prove that at the time of the stop, the officer had specific and articulable facts that create a reasonable suspicion that a crime has been, is being, or is about to be committed, citing State v. Marks. In this case, the trooper changed his story about why he was stopping Mr. Li, but neither of his stories were born out of dashcam. Neither of his stories were borne out by the dashcam video. Furthermore, although the trooper after the fact suggested that part of his basis for the stop was a potentially expired registration, he did not call in the license plate or obtain confirmation regarding the registration status until after the stop. As a result, the trooper lacked specific and articulable As a result, the trooper lacked specific and articulable facts to support the traffic stop in this case. All of the evidence and statements obtained in this case were the fruit of the poisonous tree of the illegal stop and therefore should be suppressed, citing State v. Ellis. Because hemp is legal in Kansas, the smell of marijuana does not provide probable cause. Warrantless searches are per se illegal, State v. Heim. The state will likely argue that this search, in this case, falls into the automobile exception to the warrant requirement. Under the automobile exception, an officer can search an automobile if, at the time of the search, they have probable cause to believe that contraband or evidence of a crime will be found in the automobile. State v. Doles. The Kansas Supreme Court has said that the smell of marijuana emanating from a car is enough for probable cause to search the car. State v. McDonald. In McDonald, an officer pulled a car over during a check lane stop and smelt burnt marijuana coming from the vehicle. The officer looked at the car and spotted a small metal box and asked McDonald about the contents. McDonald opened the box to reveal the marijuana. The Kansas Supreme Court reversed the district court's decision to suppress the evidence. It concluded that the officer had probable cause to search the car based on the smell of marijuana. The odor alone was enough to believe that criminal activity was afoot. Furthermore, McDonald consented to the search. The McDonald court held that automobile searches may be upheld if there is probable cause to believe that there is evidence of a crime in an automobile. They quoted Love v. 1967 Chevrolet. The McDonald court justified its holding because the smell of marijuana was always evidence of illegal activity. State v. Stevenson. However, this is no longer the case since Kansas legalized hemp growth in 2019. KSA 2019 Supplement 2-3901, Commercial Industrial Hemp Act. In contrast to McDonald, the Kansas Supreme Court has held that when a substance implicates both legal and illegal activity, the smell of the substance cannot be enough to establish probable cause. In Stevenson, the strong odor of alcohol coming from the car was not enough to establish probable cause to search the car. An officer pulled Stevenson over for failing to signal 100 feet prior to a turn. When the officer approached Stevenson's car, he noticed a very strong odor of alcohol, as though an alcohol container had spilled. The officer determined that Stevenson was not under the influence based on field sobriety tests. The officer did not see any incriminating evidence in plain view, nor did Stevenson consent to a search. Nonetheless, the officer conducted a search. The Stevenson Court of Appeals majority relied on the Kansas Supreme Court's decision in McDonald, holding that a warrantless search was reasonable under the automobile exception. However, Judge Buser, in his dissent, gave more weight to the Kansas Supreme Court's decision in State v. Ibarra and State v. Stevenson. Judge Buser opined that no Kansas court has held that the odor of a legal substance may provide the sole basis to justify a warrantless search of an automobile. The Kansas Supreme Court agreed with Judge Buser and held that the officer's failure to note any other inculpatory facts of the crime being investigated, other than the smell of a legal substance, rendered the ensuing search unreasonable and unlawful. In Ibarra, officers conducting a traffic stop for a taglight violation smelled ether coming from the car. The officers related the smell of ether with the manufacturer of methamphetamine, but also other legal sources. Based on the smell alone, the officers believed they had probable cause to search the car. The Kansas Supreme Court disagreed, ruling that the search was unreasonable. It held that the smell of ether alone is justification for an investigation, but not a search. Hemp, which smells like raw marijuana, is now legal in Kansas. Mr. Li's situation can be distinguished from McDonald. First, the officer in McDonald smelt burnt marijuana, not raw marijuana. This is an important distinction because burnt marijuana is indicative of illegal activity, whereas the smell of raw marijuana is not necessarily so. Second, McDonald gave the officer consent to search. Third, and most importantly, at the time of McDonald, no legal reason existed in Kansas to justify the smell of marijuana. Mr. Li's case is more like Stevenson and Ibarra. Hemp is now legal in Kansas. It smells nearly identical to raw marijuana. The smell coming from the Porsche had a potentially legal source. Because of this, the smell of marijuana alone cannot constitute probable cause to search. Race-based policing is prohibited. Under KSA 22-4609, law enforcement officers in Kansas are prohibited from racial and other bias-based policing. Interpreting the statute, the Kansas Supreme Court held that to invoke the statute, a defendant must move to suppress, asserting that he is a member of a class listed in KSA 2014 Supplement 22-4606D, and the reasons for arguing that race or other listed characteristics was unreasonably used in the decision-making process for initiating the stop. If the defendant shows that he is a member of a class listed in the statute that was subject to the search or seizure, if the defendant shows that he is a member of a class listed in the statute and was subject to a search or seizure, the burden shifts to the state to prove that neither race, ethnicity, national origin, gender, nor religion were unreasonably used by a law enforcement officer in deciding to initiate an enforcement action. Citing Gray. The Gray Court made it clear that this determination must hinge on more than just whether there was a traffic violation. In a case like Gray's, where the defendant urges suppression based on an unlawful but not unconstitutional search or seizure, a district court cannot focus on whether a traffic violation caused or justified a pretextual stop. Instead, the district court must consider whether race, national origin, ethnicity, gender, or religion was unreasonably used in deciding to initiate the enforcement action. This means that a judge will consider any reasons proffered by the state as to why a particular traffic signal violation was enforced and determine whether those reasons credibly, fairly, and uniformly would result in decisions to initiate traffic stops, regardless of a driver's race, ethnicity, national origin, gender, or religion. Mr. Li is Asian, therefore he is at risk of race or bias-based policing based on race, ethnicity, or national origin. The trooper stopped Mr. Li's car and eventually searched his car. This meets the first step of the procedures outlined in Gray. Pursuant to Gray, the state must prove that the trooper did not unreasonably use race, ethnicity, or national origin in deciding to initiate or continue the stop or search Mr. Li's car. The Gray Court also noted that if the state fails to prove a lawful search under KSA 22-4609, suppression is an appropriate remedy. Wherefore, defendant Liang Li respectfully requests that the court enter an order consistent with the foregoing allegations and grant such order of relief as the court deems just and equitable. Respectfully submitted, Kurt P. Kearns. There was a hearing on this motion I would have loved to have seen. During the hearing or after the hearing, Judge Satterfield ruled that the evidence would be suppressed, and subsequently there was a motion to dismiss. So the case against Mr. Li was dismissed, and I would say there's probably not a very good chance that he will be charged again just because there was no evidence that supports a basis for the traffic stop, since there is dash cam video showing that all traffic laws were followed. Fruit of the poisonous tree. Thought that one was interesting. I hope you did too. See you next time.